This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak on why it is inappropriate to waive an insurer's right of subrogation when you seek to receive benefits from that insurer, because the policy, and in many states the law, makes it improper for an insured to deprive the insurer of its right of subrogation. Following a vehicular accident, Martin Petite entered into a release and settlement agreement with the driver of the other vehicle and her insurer. Petite did not seek a waiver of subrogation or consent from his own automobile insurer, Mississippi Farm Bureau Casualty Insurance Company, prior to executing the release and settlement agreement. After the release and settlement agreement was executed, Petite then filed a complaint against Farm Bureau seeking damages under the uninsured motorist provision in his auto policy with the Farm Bureau. Farm Bureau moved to dismiss the complaint, and the county court declined the motion. In Mississippi Farm Bureau Casualty versus Martin Petite, the Supreme Court of Mississippi on April 6, 2023, resolved the dispute between the Farm Bureau and Petite. Martin Petite, of course, was injured in a two-vehicle accident with Mauricia Bland. After the accident, Petite entered into a full, final, and absolute release of all claims, settlement, and indemnity agreement with Bland and her insurer, Mountain Laurel Assurance Company, in exchange for the payment of $25,000. Petite then filed a claim against his own insurer, Farm Bureau, alleging that Farm Bureau breached its contract with Petite. Petite argued that the UM provision in his auto policy with Farm Bureau covered up to $50,000 per accident and was intended for this exact purpose. Since Petite received only $25,000 in the agreement, Bland's policy limit with Mountain Laurel, he argued that the remainder of his damages from the accident should be paid to him by Farm Bureau under the auto policy's UM provision. Farm Bureau moved to dismiss the complaint for failure to state a claim. Farm Bureau argued that since Petite had entered into the agreement with Bland and Mountain Laurel without first seeking a waiver of subrogation or other consent from Farm Bureau, Petite was barred from proceeding against Farm Bureau under his UM coverage. Mississippi law established that Farm Bureau had a right of subrogation, and Mississippi case law supported its position that cutting off the insurer's right of subrogation prohibited the insured from further proceeding against the insurer for a claim under the insurance policy. Farm Bureau argued that the agreement executed between Petite, Bland, and Mountain Laurel cut off its subrogation rights, which it was entitled to statutorily and contractually, and barred Petite from proceeding against Farm Bureau for damages under the UM coverage. Aside from the contractual requirements to give consent to any settlement of claims and to be subrogated to an insured's right to recover, Mississippi Code Section 83-11-107 provides that an insurer has a right to subrogation. The law has long established in the state of Mississippi the insurer is prohibited from proceeding against the tortfeasor. The insurer has no further rights to proceed against the insurer. The Supreme Court has stated that an insured who executes a settlement and release agreement with an uninsured motorist, effectively cutting off their own insurer's right of subrogation, cannot then proceed against their own insurer. Subrogation is the substitution of one person in place of another. He who is substituted succeeds to the rights of the other in relation to the debt or claim and to its rights, remedies, or securities. Farm Bureau had a right of subrogation by statute and contract. The execution of the agreement between Petit, Bland, and Mountain Laurel cut off Farm Bureau's right of subrogation without Farm Bureau's consent. Farm Bureau, therefore, had no duty to pay for Petit's claim under the UM provision. The Supreme Court reversed the trial court's denial of the motion to dismiss and rendered judgment in favor of Farm Bureau. In my opinion, Farm Bureau's policy required the insured to protect its right of subrogation, as did the Mississippi statute. Petit, on the other hand, released the person responsible and in so doing deprived his insurer of its rights of subrogation, and by so doing destroyed his right to seek indemnity for underinsured motorist coverage. Failing to protect the rights of his insurer cost Mr. Petit $25,000, plus the time and effort to sue and deal with the appeal. He may not be without a remedy if the agreement to the release was based on the advice of counsel, because that violated the policy terms and the state statute, and that advice would have been wrongful and give Mr. Petit a right to sue his own lawyer to recover the extra $25,000. This video was adapted from my blog, Zelma on Insurance. It is available free to anyone who clicks on the link zelma.com/blog. That URL will take you directly to my blog postings. You can subscribe to the blog and you'll be advised of all new blog postings. I don't sell your address, I just provide you with the information. You can also subscribe to the YouTube video or the Rumble video or both. And if you found the video to be useful to you, please tell your friends and colleagues so that they can also subscribe. And you might also be interested in becoming a member of my locals community or subscribing to my Substack publications where you can get additional information. Thank you for your attention.